And then in the meantime, there he was indicted, and so I filed a motion for a bond reduction.
Okay, and is that in both cases? Or just the,
and the newly
the new-
indicted case?
We have
Right.
a set bond, I believe, in the.
we have already
We have
I
not.
have not. And so.
in the murder or in the MTRP?
In the MTRP.
MTRP, and so I don't know if that's going to be.
He's entitled to a bond in that one because it's a deferred. And then a bond should have already been set in the murder.
All right, so you're Thaddeus McCray.
Yes, ma'am.
And so, Mr. McCray, in clause number 21-38959, has a motion to revoke his probation, the underlying offense of aggravated assault causing serious bodily injury. And then we have clause number 26 VCCR 0399, which is the new indictment charging Mr. McCray with the offense of murder. Ms. Brazo has filed a motion asking that I reduce the bond in the murder case. And while we're here, we obviously need to talk about a bond being set in the MTRP case as well. And so the bond in the murder new indictment is set at $1.5 million. And then there's no bond in that MTRP. Is that correct?
That's correct.
All right. Are you, Mr. McCray, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Brazo, you may proceed.
Would you state your name for the record?
Right.
And we're here today on the motion to reduce your bond that's currently set at $1.5 million to $50,000. Is that correct?
Yes, ma'am.
If the court were to reduce your bond, do you have any assets that you could sell to make money to possibly make your bond? Do you have any means of making that bond that were reduced to $50,000?
Possibly,
Okay, could you explain?
like just a car, like I was just renting things like that. So person I don't like own a house or anything like that. My door, my
Speak up. I'm sorry.
Oh,
I
excuse
have to hear you, and so does the
Sorry.
court
I
reporter.
don't own a house or anything. I was renting, but I do own my car.
Do you have?
So that'd be my own means,
Okay.
and then my other assets like clothes and stuff like that. So
What about family members? Do you have any family members that could potentially help you
that's
post your bond?
this is the possibility.
And are you asking the court if you are placed, if the court does reduce your bond, that you be placed on house arrest or have a GPS tracking device that would only allow you to leave your house for meetings with me, your attorney, or medical purposes?
Yes, ma'am.
Where would you be residing? That relates to my bond. If that were to happen. Where would you reside?
More likely, I have to check with my sister.
Is that the only place that you would have to go?
No, now, but I know, my friend, I know he's real busy. They both stay in Houston. So technically right now, I can check with some other family members. I know they all work and everything, and I have to talk to them first. I just can't say yes and voice into their on welcome.
Now, these family members, are they within Jefferson County?
Yes.
And who are the family members?
Sisters.
So you have a sister that is here locally?
Yes, and I have them in Dallas.
Okay, what is your sister's name?
With,
That's here locally.
there's a couple of them, but, Michelle.
Shh. I'm having a really hard time
Michelle?
hearing.
Yes, that's one of them.
Thank you.
And what is, do you know her last name?
This name is mine.
Okay, I was just making sure. Where does she, do you happen to know her address?
I just know she's staying in West End.
Have you been in contact with her recently?
I talked to him, I got here, my father passed. Haven't really spent too much time on the phone unless it was like with my good friend. You know, I ain't really had much money to put on the phone. So, I was still in this MTRP phase. So it was really nothing for me to keep in contact with.
Okay, that's all I have, Your Honor.
Any questions of the witness, Mr. Smith?
No, Judge.
Any other witnesses with regard to the bonds?
No, Your Honor.
I am, for the record, taking a look at the probable cause affidavit and the new case. So give me just a second to go through that. Mr. Smith, what is the state's position with regard to bond in each of the cases?
I believe that the bond in the murder case is not set too high, and I believe that he is entitled to a bond in the MTRP because it's a deferred probation, but we would ask that a high bond be set in that. I believe we will be seeking to stack these cases, punishment in those cases. So we believe that he will be in prison for a significant period of time. After he committed the murder, he did flee the jurisdiction and was located in Houston.
Do you know how long that was from the time?
It was, I don't remember, it was several days or more.
Give me just a second. I'm looking back now at the previous pre-sentence report. So just to get an idea of what the underlying,
Excuse me, I know.
hang on just a second. I'm on that.
If you recall, Judge, this is the case, we were in trial on the sexual assault, and the state had rested. And when the state rested, the defense wanted to recall the victim,
Yes.
and the victim we were unable to locate to bring back.
Okay.
And so that was the reason that he pled to the aggravated assault rather than was sentenced by the jury to the sexual assault.
Gotcha.
Your Honor, if I can allow Mr. McCray to respond to the fact that, or to the statement that he was in Houston, if I may.
Sure.
Okay.
I was never in Houston. I never left this jurisdiction. I was found at my ex's house the next day. I never left.
And on Euclid.
Yes, I never left.
Okay.
So for me to flee, never left.
And that is correct, Your Honor. He was arrested at Euclid, and there was some steps that were taken after that to search the residence,
Right.
and so forth. But it's my understanding from that point, which was either the next day or within a few days, he was apprehended there.
Okay. I think you have some misinformation on that maybe, or?
There was some info, I don't have the file with me, Judge, I just remember reading that they had suspected that he had been in Houston.
Okay.
But now that I think about it, we have found the motorcycle that was used in the murder.
There's no more.
There's
You're thinking of,
It's a different.
You're thinking of a different case.
It was that one.
That's the other case I've got cited. I apologize.
Yeah.
I'm getting confused.
Okay.
Do you have your file in this case?
I don't have it down here. It's upstairs.
Okay, so on the offense date. Okay.
Your Honor, also, if I may allow Mr. McCray to speak about this, since the underlying offense for him being placed on deferred adjudication, there were some allegations made as to what happened that he would like the court to be aware of. And I wasn't part of that.
That's all
case,
done.
so I
On
just-
probation
okay.
for it, entered a plea of guilty to the aggravated assault. I was there, listened to
Okay.
the trial. I don't need any other information on that. So in cause number 21-3855959, I'm sorry. Which is the motion to revoke unadjudicated probation. I'm going to set the bond in that case at $400,000. Condition of that bond, if made, is that Mr. McCray would be on house arrest with a GPS monitoring device. I'd obviously have to have an address locally where he would be. And then in clause number 26, DCCR 0399, going to second. I'm going to grant the motion to reduce the bond. I'm going to reduce the bond in 26 DCCR 0399 to $1 million. Condition of that bond also, if made. A condition of that bond, if made also, is that you will be required to be on house arrest where a GPS monitoring device. We'll get the case set for an announcement, obviously, make sure, I'm sure there's a lot of discovery. Has all of that already been turned over? Is there anything missing?
I believe that we have received everything. I'm in the process of reviewing it. It's quite voluminous. So,
All right.
if something comes up, I'll let the court know.
All right, Mr. McCray, I'm sure Ms. Prazo will be out there to start going over the discovery with you so that we can see about getting an announcement which way your case will go at the next court date. All right, you can go back with the bailiff.
Thank you.
Apologies for mixing up the cases, Judge.
That's okay. Good morning, you're Desarian Adams.
Yes,
And this is cause numbers 23 DCCR 0492 and 0493. Mr. Adams is on probation in each of those cases for deadly conduct, discharging a firearm. There have been motions to revoke filed in each of those cases. And what is the announcement?
Judge, Mr. Burbank had requested the videos from the underlying misdemeanor cases that make the basis of the motion. We had sent through the online portal the link, and he informed me that it didn't work. So we'll have to physically copy those from him.
Okay, so one reset, you should be able to get that done, go over it with Mr. Adams, and we'll get an announcement, you think?
I mean, we were gonna plead, you didn't want us to plead to some of the counts, some you wanted to announcement on all of them. And
Right.
Video, Judge.
So that was, when was our last, was that?
It was about 3 or 4 weeks ago, Judge, and I was in trial. Mr. Burbank was in trial and had a wedding. And I followed up the last few days, trying to get the thing copied. I was informed that's on this online portal, so we sent the link, and then found out it didn't work.
Okay, so I'll do just a normal reset, make sure y'all get it taken care of.
We just have to do it the
soon as-
old-fashioned way and get it to them.
Okay, if you'll get whatever they need, I don't know if they'll need a thumb drive, get whatever they need, and so we can get an announcement at that next court date. You can go back with the bailiff. Mr. Burbank, you have Elazar Stansberry.
Stansberry.
Good morning. Are you Elazar Stansberry? Eleazar, and Mr. Stansberry is charged with murder in cause number 26 DCCR 0174. And it looks like Mr. Burbank has filed a motion asking that bond be reduced. It's currently set at $500,000. Mr. Stansberry, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you, Mr. Burbank.
Here's for the record statement.
Eleazar Stansberry.
Now, Eleazar, we're here to request a bond reduction, is that correct?
Yes, sir.
It's currently at 500,000.
Sir.
Do you have any bank account with any substantial money?
No, sir.
Speak up.
No, sir.
And do you have any IRAs, retirements, any type of property that you could possibly put up as collateral?
No, sir.
You were asking that the bond be reduced,
Yes, sir.
and so an amount that you'll be able to make, is that correct?
Yes, sir.
You have, if you are able, if the bond is reduced, will you be able to stay in the area?
No, the last time I came, Miss West told me I can go to girlfriend's house in Harris County.
Okay. And so that's where you be staying?
Yes, sir.
You know that you would have to get a GPS device.
Yes, sir.
And there'll probably be some rules and regulations, I believe, that the judge probably set for you in reference to where you could go and where you couldn't go.
Yes,
And would you comply with those rules?
yes, sir.
Your Honor, before I was court appointed, I think Ms. Holmes asked for a bond reduction.
I don't see that there was a motion.
No,
That's what I was looking for.
yeah, I mean, I went out there. I went out to see Mr. Stansberry, and in between there and Ms. Holmes, I guess he was on a docket or something, and he requested that it be reduced. They reduced it down to 500,000 before.
So what's changed then? If I've already reduced it,
Since then, since then, he has tried the 500,000. This is my first bond hearing, Judge, and I don't know why he got in front of you before, but it did.
yeah, I see that it was initially set at 1.5 million,
Right.
reduced to 500,000.
We're asking Judge that it be reduced down to 150, 175.
Mr. Nichols?
I see no reason the bond should even be at 500, Your Honor. Besides this case, he has a weapons charge also pending that predates this murder, a misdemeanor, involving a firearm. He's been in fights in the jail. He's done nothing, I don't understand why we got down to 500, to be honest, Your Honor.
Well, and I don't recall, and I don't see anything in the case on that either. So, yeah, I think at this point, based on the nature of the offense, I have taken judicial notice of the court's file, which includes the probable cause affidavit. There's not a whole lot of information in it, but enough that I believe that based on the offense charge, the fact that there's already been a bond reduction and what Mr. Nichols has provided with regard to another underlying weapons charge, I'm going to deny the motion to reduce the bond any further at this point. So we'll reset a case and get it for an announcement as quickly as possible.
If we could, Judge, we'll be able to announce it next.
All right, thank you. You can go back with the bailiff.
Big seat, Your Honor.
Thank you.
Thank you, Your Honor.
Don't let me look at the camera myself.
Good morning. Are you Carlos Rodriguez?
Yes.
And just for the record, Mr. Salinas, you're going to be able to translate for Mr. Rodriguez today.
Yes, Your Honor.
All right. And Mr. Rodriguez is charged in 24 DCCR 1584 and 1585 with indecency with a child by sexual contact. And what is the announcement?
Ready, Your Honor. I guess last time we were here, we had to deal with the inspection videos. So it looks like that was, I'll bet after your order was signed, both me and the state were able to get those videos and an investigative report
Good.
there. So, and I believe state also filed motions for you to do an in-camera inspection of some CPS records regarding the children.
That's correct, Your Honor. There could be exculpatory information there, and so I do like to request those records if
Yeah.
necessary.
I signed that order just yesterday.
Okay. Yeah,
So that takes a little bit to get those records back.
understood. And I was unopposed anyway to that, so that's fine.
All right, so I guess what we need to do is reset it to get those records back. And then as soon as that happens, and typically what happens is they send 3 copies. They send an unredacted version to me, a redacted version to both of you. So you'll be able to go through it yourself. If there's something that you feel like has been redacted that I need to take a closer look to, or closer look at, then you can let me know. So we'll just do a normal reset. It's not likely we'll have them by then, but
Understood.
if you think, just because this has been going on a little bit,
Yes.
he's in custody, if you'll get with,
Bourdain?
Miss Adams.
Miss Adams. I didn't want to say, I was about to say her first name. I couldn't, but yeah, if you'll get with Miss Adams and see if they can kind of move this one to the top of the list for us, since he's in custody and we're waiting on it now.
And Your Honor, speaking with the state earlier about, just as far as trial dates go, August was mentioned. Is that about as far as?
So what'll happen is, we have to get to that point to where it gets placed on the trial docket. I don't just put anything on the trial docket to kind of get more time. I want everybody to have all the discovery and then for it to for sure be a rejection of any plea agreement. And so what'll happen is once you are prepared to reject any offer, there's a document you'll do, a plea bargain rejection, so that I have something in writing.
Yes.
As soon as that's done, it'll get placed on the trial docket. Our trial dockets are about 2.5 to 3 months
Okay.
turnover from the time that you get on it to the next
And
one.
I'll get a date with her.
But we'll need that rejection first and everything. And so I'm assuming you don't want to reject until you get the CPS records.
Yeah, and right now the current offer was from the last prosecutor. Ms. Pam here hasn't gotten a chance to fully review and give her own.
So I'll just do a normal reset and then Ms. French can get an offer to you, and then we'll see where we get with regard to getting those records back. And as soon as that takes place, we can get it moved to the trial docket if that's what it's going to be.
Gotcha.
Okay.
Yes. Thank you.
Thank you. You can go back with the bailiff. Okay, so you are Larry Fitzgerald Williams?
Yeah.
And Mr. Williams is charged in cause number 25 DCCR 0985 with capital murder. And Mr. Cash, it looks like filed yesterday, we're here just on an announcement, I believe, but filed yesterday, a motion to compel the state to declare their intent to seek the death penalty or not. And Mr. Smith what is the state's position? Do y'all have one yet? I think that's obviously very important at this.
Yes.
This is from a murder from June of 2025. So if it's not been declared, I think it's time. I would agree.
Well, as far as I understand the law, Judge, the punishment for capital is the death penalty unless the state waives that. We've not waived it yet.
I understand what the law is. I also understand that the case needs to be set up a whole lot different from the court's perspective. If we're going to set this for trial, then we need 6 or 7 weeks. From Mr. Cashin's perspective, he's got a very different potential strategy and mitigation and all of that kind of stuff if we're going to go. And so I don't disagree that the state needs to make that decision. It's time for all of us to be setting it for trial or working something out. And if I'm going to set it for trial, I need to know what I'm setting it for trial for. So here's what I'm going to do. I'm going to reset the case, one reset for you to meet with whoever you need to meet with. I am going to order that there isn't an answer because we will be either setting it for trial or it'll be the end of the announcements. It's either going to be worked out as some type of plea or we're going to be setting it for trial at that next court date. And I need to be able to know what I'm setting it for. So get with whoever you need to get with. Let's get an answer between now and then so that we all know how to go forward. Since we're at that point, we'll be 10 months out. So it's time to figure out what to get it set for. So I'll reset it and we'll get that at that next court date. All right. You can go back with the bailiff. Good morning. You're Caleb Luskowski. And this is 21-37917. And Mr. Luskowski has a motion to revoke probation. Underlying offenses evading arrest and detention with the use of a vehicle. And what is the announcement?
Your Honor, you'll note that this was filed
2022.
22.
Yeah. So
He subsequently, after part of the basis of the motion was 2 convictions out of a different county, and he went and did time on those. And so we can either if the court's inclined to take our pleas to the allegations contained in the state's motion, we can do that. Or 2, like figure out how much time he's got. It matters to the court.
well, have you talked to Mr. Smith?
I haven't.
Okay, I'll hold the case. Y'all visit about it because it may be that y'all can get that information and get an offer and work it out this morning.
My fear is it's going to be scattered across a couple of counties and a couple of state institutions. It may not be readily ascertainable.
She's looking to see what she can find out, but y'all talk about,
Okay,
possible, whatever y'all can. Talk to Mr. Smith.
I will.
Ms. Warner can work on credit potentially, and then we can see if we can get an announcement.
I think you can call.
Mr. Galmore, morning, Ms. Burke. Please raise your right hand. Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? Yes. Thank you. Good morning. Good morning. Are you Heriberto Chavez?
Two.
Yes.
Yeah.
And Mr. Chavez is charged with deadly conduct, discharging a firearm, and cause number 25 DCCR 0559. And what is the announcement?
Judge, we're still asking for a little more time, trying to get through all the discovery, and he is, he's here at, thank you, LaSalle. And so there, that makes it a little more difficult to communicate with him. So if I could have just a little more time to get through that.
So what I'll do is one more reset. This will be the last reset for an announcement. If there's any issue with visiting at LaSalle or bringing a computer to show him things, if you'll just get with my staff, they can have him brought over and you can visit with him in the jury room.
Okay.
And bring your computer and show him everything so that we can get that all done before that next court date.
We can do that. Thank you.
Okay.
Appreciate it.
Perfect. So I'll reset it. Just get with them. We're kind of down quite a bit this coming month. So you'll have some time to go through that with him.
Thank you, Judge.
Yes, ma'am. No, we're going to start.
Okay.
Good. Nice to see you again. You too. You got me quick, huh?
Good morning. You're Traylon Hill?
Yes, ma'am. How you doing this week?
Good. And so I'm going to take judicial notice of the court's file. The last time we were here, we wanted to double check and make sure that there were not issues with regard to competency based on some of the behavior and things that Mr. Hill was doing and saying. And so we had Dr. Rapon do a competency evaluation. I received that report dated January 24th of this year. And in that report, the finding is that Mr. Hill is competent in stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
None in regard to competency.
All right, then at this time, based on that report, I am going to find Mr. Hill competent to stand trial. Ms. Perazo, I know you are a little newer on the case. We've gone through some attorneys, but it is time for either a trial or a plea. So I need to know today if you want to visit with him in the back real quick, whatever the latest offer is. If he wants to reject that, we'll get it set on the very next trial docket. If not, I want it taken care of this morning.
Yes, ma'am.
I'll hold it.
Get that offer.
I'll hold that. All right, go back to the bailiff.
Okay, I'll maybe give you in just a second. I think
In February. I mean, yeah.
Judge, just tell you what I've done. I've reaffirmed the last offer I made with Mr. Burbank, which was 12 to Ms. Perazo. I think it would help if she had a little time to talk to him.
Yeah, that makes sense. I knew it had been going on, and obviously it's not your fault that the case has been going on for a while. And so I'm going to ask you to do the best you can
Yes, ma'am.
to kind of just stop talking.
Okay, I didn't go for that.
So, Mr. Hill, we've gone over this before. If I'm talking, you don't talk because this lady's taking everything down and she can't type us both at the same time.
I'm just trying to defend my right.
Ms. Perazo,
For 17 times.
I understand that. I'm tired too.
Very tired.
Me too. Trust me. We're going to get your case taken care of. Ms. Perazo is going to get on board as quickly as she can. She's got a lot to go through in a short amount of time, but she's going to do that for me. And so that we can get your case moving in the correct direction very quickly. Give me just a second to look for something, okay?
And
I don't see.
I don't think we ever did a formal rejection of that. And it really doesn't matter for today, Judge, but
So what we'll do, I don't see that there was a formal rejection done. So visit with Mr. Hill about what the offer is. It is what it is now. Doesn't matter what it's been in the past or what you think it's been. Mr. Hill, Ms. Perazo, get an offer from the state. If y'all want to reject that at the next court date, let's get that taken care of and we'll get it on the trial docket if that's what it needs. Otherwise, we'll get it taken care of at that next court.
Okay,
Thank you,
thank
Ms.
you.
Perazo. I appreciate you getting up to speed quickly.
thank you.
Good morning. Are you Samuel Jones?
This,
And this is cause numbers 25 DCCR 0043 and 0232. Mr. Jones is charged with burglary of a habitation and burglary of a building. Last year, Mr. Jones was found not competent to stand trial and was sent to the appropriate facility for competency restoration, which was the Dunn Behavioral Science Center. We've received the trial competency evaluation report from them. I'm going to take judicial notice of the court's file. The opinion at this time is that Mr. Jones has not regained competency at this time, and that further treatment would be required. Hold on, let me get to it. So the further inpatient treatment would be required for competency restoration. Is there any other evidence with regard to competency?
No, Your Honor.
Mr. Smith? Then at this time, I'm going to find that Mr. Jones is still currently not competent to stand trial, that further treatment inpatient for competency restoration is indicated, and order that Mr. Jones be committed for a period of not to exceed 1 year for competency restoration at this time. If competency is achieved before then, they'll let us know and we'll get Mr. Jones back and move forward with his cases. All right, Mr. Jones? Keep doing, it sounds like you're getting better and you're taking your medication that they're telling you to take. And so you're on the right path. Keep doing everything that you're supposed to so that we can get you back here and get you taken care of. Okay. All right. Yes, sir.
In a high-stakes court hearing, Thaddeus McCrae, already on deferred probation for aggravated assault, appeared before the judge after being indicted for murder. His defense sought a dramatic reduction of his $1.5 million murder bond to just $50,000, arguing he lacked significant assets and would comply with strict house arrest and GPS monitoring. Prosecutors opposed the request, citing the seriousness of the charge and the potential for a lengthy prison sentence. During the hearing, confusion briefly arose when the prosecutor mistakenly referenced another murder case before correcting the record. After reviewing the evidence, the judge partially granted the defense's motion, reducing the murder bond from $1.5 million to $1 million, while imposing GPS monitoring and house arrest if released. The court also set a $400,000 bond on the probation revocation case under the same conditions. The hearing concluded with the case moving toward the next stage as attorneys prepared to review extensive discovery before trial.